Usually I like to give credit to libertarians for having a little bit of intellect. I mean, just really a little bit, but a little bit. Not a lot. You can often find a crumb of wisdom in their babbling every once.
Oh God, I keep having crazy hair when I come on. It's in that in-between stage. It was nice and short, but anyway, I see whenever I want to do things, I have to do it backwards on camera. Anyway, I hope you all are doing well. Let's take off the Lucy cam because I've got a laptop here that is covering up where you can see Lucy. So you'll have to do without Lucy this time. Let me do just a quick YouTube intros and then we'll get right into it. I'll show this again at the end. I would really appreciate it if you would follow me on Twitter, which is Karen Ann Harlos. My logo's in the way there. Let me move that down a minute. Really appreciate it. Also, if you could support me on Patreon, which is patreon.com/Pink Flame of Liberty. It really helps keep this show going. This show is a patron request. So what that means is one of my $25 a month patrons has requested this topic. It's a benefit that people who have been at that level before just don't claim, but you can claim it. I do reserve the right to say no if it's something I don't think I can handle. You know, it's just not something I either feel comfortable talking about or think I can give a somewhat coherent show about, but that's never happened. But I do reserve that right. So what else did I wanted to say? I don't remember. I do want to do a little bit of promo up here. You got this way. Got to go opposite. Republicans are red, Democrats are blue. Taxation is theft and embezzlement is too. This is merch at my store. You could get the link down below. I am showing a sticker up there, but we have it in t-shirts and mugs. The mug is actually pretty cool. So go check it out. I'd really appreciate it. That's another way you can support the show. And there's other merch if you're watching on YouTube. In the low bar, there's like a little Teespring banner and you can see some other merch there. So what's this show about and what's going on? I want you to comment because one reason I did have a script. So and I'm going to use it for some notes. I've got it here on my laptop. And then I decided not to use it because I want to interact if there are any comments. There may not be, but if there are, I mean, substantive ones, there's always highs and stuff like that. But if there are substantive ones, I want to interact the best that I can. Now, first of all, I am going to be giving this disclaimer a million times over. I am not an attorney. Do not take anything I say as any kind of legal advice. I am going to give you my experiences dealing with the court system as a pro se, both a plaintiff and a defendant. A plaintiff several times, so a petitioner, then plaintiff. Those terms are somewhat used interchangeably. I think actually in all of these, in the two that I was on, what would normally be called the plaintiff side, I think it was technically a petitioner. And I believe on the side where it might have been called defendant, I was technically a respondent because the defendant one was a motion for injunction. And that generally is a petition. I'm sorry, I'm getting off into the weeds. So while I am not an attorney, I am a career paralegal. So I am a bit more familiar with the court system than your average person. Now, that can be certainly an advantage because I know basic things like the difference between petitioner and respondent, and I know the names and forms and workflow of a basic case, which your average person, your average electrician, is going to know how to wire our hot tub for 220, which we need. And if I even remotely thought about doing something like that, I'd burn the house down. So there is somewhat of an advantage there. Now, whether it's an advantage, I mean, it's certainly an advantage in the procedural realm, but whether it's actually an ultimate advantage, because I think it could make you more confident than you should be. This is going to be a very sober look at being involved in the court system pro se. So, already said I'm not an attorney. I'm going to give you another piece of advice that I really, really hope you listen to, particularly if you don't have any legal background at all. Do not use AI. Can I say that a million times? There was someone on the LNC, and I'm not saying don't use it at all. I am going to qualify that, but do not use AI to write your legal filings in total. Even if you say to the AI, go out and check these cases and make sure they really exist, and they say what the AI is telling you they say, even if they come back, no, 100%, go read the cases yourself. AI, I have found, because I like to, since I am a paralegal, I like to play with AI for hypotheticals. Like a situation will come up and I'll just go in and just play around with AI. Everyone knows I'm not a huge fan of AI. I'm waiting for the Butlerian jihad, to be honest with you, but it's here. And I do that, and I can cuss at it, which I like, which I used to do with Siri. Just to go off on a little bit of a tangent, unfortunately, I trained Siri to have a potty mouth. So one time Siri was listening to me and thought I said to send a text to Ken Molman. And I don't know what was going on with what Siri was listening to in the car, but a text almost went out to Ken Molman that I can't say on YouTube, and you know I'm pretty loose on YouTube. I can't even say on YouTube the string of words that it put together that I am so grateful it did not send to Ken. Now, fortunately, AI does not do that. So I can tell it to go itself and whatever, and ask it what it's smoking and whatever. But I am telling you, someone on the LNC got in trouble for this. His story, and I don't want to say story as if I disbelieve them, because I can see this really easily happening. I have accidentally almost uploaded the wrong versions of pleadings, but there was a pleading that got submitted to the court by this LNC member in their own state dispute, I think with the Election Bureau, and it had 2 hallucinated cases in it. And this LNC's member said they didn't do that on purpose. They accidentally uploaded to the court an earlier version. I've almost done that. So I can kind of understand that. I don't know if it's true or not, but it should be a warning story, because sometimes even if the case does exist, and even the proposition that AI is telling you that the case says is actually in the case, the context changes its applicability to perhaps your case, or it's citing it in a dissenting opinion. And if all of these terms are absolutely Greek to you, I hate to tell you this, but you need an attorney. Let me give you a statistic you may not care for. And we're going to go into some specifics actually here, but we're doing introductory here. Let me just look at my notes here. And I did get this actually from AI. Hopefully it's correct. That said that statistically, and it searched state courts and federal courts, and I stuck to civil, not criminal, show an 80 to 90% failure rate of pro se litigants. I would have loved to have that broken down to people who had somewhat of a legal background, people that didn't, there's a lot of different factors that go into that, but that should be a sobering statistic for you. I wanted to give you the reality. Now, also, though, if you are financially strapped, there are low cost and free options. Often the self-help center, through whatever court you're dealing with, can refer you to certain services. But let me tell you what you may consider not being able to afford an attorney, and what these programs consider not being able to afford an attorney, are two entirely different things. Like, generally speaking, it's been my experience, might not be true in your jurisdiction, you've got to be dirt poor to qualify. You know, maybe you've got an attorney friend or something that can help you, because if you can afford an attorney or have access to an attorney, choose that every day of the week over going pro se. The system is geared to favor the attorneys. That might be right in some cases, it might be wrong in some cases. I am not giving a value judgment. I am just telling you how it is. Let me see if there's anything background else I put in the notes. Then we're going to go into some specifics. Now, it's not going to be a terribly long show unless there are some questions. Oh, I see what else I wanted to add. I know there are legal insurance plans out there. I think like Legal Shield is one of them. I don't know anything about them. This isn't for or against them. I just know from anecdotal stories from some of my friends that have had these, they don't really cover much. More so, well, they don't cover usually when you want to be the plaintiff, and they cover in certain circumstances when you're the defendant. Let's see what else here. Umbrella liability policies will help you a lot in indemnification if you are a defendant. Okay, so I like what I wrote here that I want to say. If you're going to be a plaintiff in a case, that is a choice. It's a choice that you affirmatively make. And if you think your cause is in fact just, and you are willing to research the court rules, because even though you're pro se, you are accountable to know the court rules, and you could take the time, because it's going to take you a lot of time. After everything I said, don't be scared to secure justice for yourself, but weigh the cost. There's an emotional cost, there's a time cost, and there's a monetary cost. There will be filing fees, and those can be extensive. Let me tell you something ridiculous when you want to talk about filing fees. Generally speaking, the filing fee, you would think the filing fee in the District of Columbia would be outrageous. I mean, everything in DC, you just think fraud, corruption, high costs. It's like $120. In Colorado, if I remember correctly, it's $330. That is a big difference. Then you are going to have service of process fees. And what that means is serving the defendant, or if there's multiple defendants, with the suit. If you're not in a hurry and the person doesn't live in a remote area, you're looking at $80 probably. And if you're doing expedited service of process, it can be a lot more. Of course, you can have things served through the sheriffs, and that's generally a lot less, but also a lot slower. Also, depending on where you live, so let me give you some background on that. Most states follow what's called the American rule. And what the American rule means is both sides bear their own attorney's fees and costs, no matter who wins. There are statutes, though, that can change that. So depending upon where you live, whether or not they follow the American rule, and whether or not there's a certain statute that covers your kinds of case, you could be responsible for attorney's fees. So you also need to keep that in mind. Okay. Let me see if there's anything else in my notes. So I wanted to give one of the examples here. Because I am a career paralegal, I'm not intimidated by the court system, and that most people are. And that actually grieves me, because I think the average person is priced out of justice. because attorneys' costs are so high. And I'm not saying they're not worth it. I'm, again, just giving realities here, very few value judgments. And they don't feel confident to be pro se. And the fact is, then they can be taken advantage of by people who can. That's just the way that it is. So it really does grieve me. And I can't imagine being somebody, let's say, a defendant in a case. I can't imagine being a defendant, because being a plaintiff's a choice. Being a defendant is not. And let me tell you something crazy, and I'm sure this is true in most states. I know it's absolutely true in Colorado. If you are going to respond to the lawsuit, particularly if you think it's unjust, like you weren't a contractor that broke a contract, nothing like that. When you go to respond to the lawsuit, you have to pay a pretty hefty sum just in order to file a response to something you might think you were just living your life and had nothing to do with. So the plaintiff's already paid $300. You have to pay a couple $100 just to defend yourself, just for the privilege of filing a response. And that, to me, is just so crazy. And I can't imagine how this would be to someone who doesn't know the difference, as I do, and it's not because I'm smart or anything, it's just because it's the field I work in, between a motion to dismiss and a motion for summary judgment. Not knowing what an interlocutory order is, not knowing what is appealable, what is not appealable, how exactly you appeal, what the difference, at least in Colorado, because here's also what's confusing. Each state, because we're not dealing with federal courts right now, though we could be, each state calls its court system its own thing. So in Florida, where I used to live, the trial court was called the circuit court, and the appellate court was called the district court, and the federal trial court is the district court, and the federal appeals court is the circuit court. In Colorado, the trial court is the district court. And the federal trial courts are called the district court, so at least it's a little bit more consistent. In Delaware, the trial courts are the superior courts. And if I'm not mistaken, have never done any cases in New York, but I think the trial courts there are called the Supreme Courts. It's very, very inconsistent amongst states. Federal court's the same throughout the country. Okay, but the rules can be different. 11th Circuit still requires bound appeal appendixes. If you work in the legal field, you'll know how crazy that is. When we've had PACER forever and electronic filing forever, they still require physically printed, color-coded, bound appeal appendixes. Insane. Okay. All right. So we're going to get into some specifics. So there's 3 cases I want to talk about that I've been involved in pro se. First, we're going to go way back to when I was living in Florida, maybe about 15 years ago, where I handled my own divorce, not from soup to nuts, but I picked up after an attorney filed the divorce complaint, but I took it over from there because I just couldn't afford an attorney anymore. And actually, I had a very good result in that. So, I was paralegal at that time too. So even though I didn't know family law, couldn't afford the attorney, I just picked up from there. And I'll tell you one thing, I'm not going to give names or anything like that, but in my ex's financial disclosure, he claimed he was paying rent to a certain somebody. The person he said he was paying rent to is actually, if I remember correctly, because this person was a very good friend of my ex-husband's, maybe his best friend, the police officer that shot Corey Walker in Royal Palm Beach, was it in Palm Beach Gardens in Florida? Was that about 15 years ago? He was staying with him. He put on his financial statements that he was paying a certain amount of rent. to this individual. So in discovery, actually, I filed a non-party subpoena for records because during that period of time, tax returns were filed to show that to see if that person claimed this alleged rent as income. Whatever. I won custody of our bird in that case because I had to go to court because there was food bills and vet bills for this bird. That wasn't my bird. It was his bird. And he wouldn't pay the vet bill or for the bird's food. So the judge said, I guess it's your bird now. Yeah, I won custody of a bird. Anyway, so that was a positive experience. Then I had been involved in 2 cases in Colorado, and we're not going to get into, well, we're going to get into the specifics of one of them, and we're not really going to get into the specifics of others. They were both party related, and why I feel comfortable getting into the specifics of one of them is because it was already very public. I don't care to make legal matters terribly public. That's just whatever. But this one was already public. So it is fairly well known that I filed suit against the Libertarian Party of Colorado in 2024 over their illegitimate attempt. I do have a parliamentary opinion to back that up. They disagree. Illegitimate attempt to put Robert F. Kennedy Jr. on the Colorado Libertarian Party ballot line. It was a suit filed as a member of the Libertarian Party of Colorado. Now, I knew bylaws well. I knew contract law fairly well because I had been an insurance defense paralegal for decades. And what are insurance policies other than contracts? Now, they're a specialized form of contract, have a lot of specialized laws that apply to them. But what I didn't know, and I still don't know, I mean, I know much better today than I did then, but the minutia of election law. Never been an election law paralegal. So I viewed this as a breach of contract case, but it diverted very quickly into an election law case. So I had to do a lot of reading and being willing to try to interpret the law. And you could easily find yourself in that position. Now, that case only lasted a month and a half. So if I remember correctly, what I had filed was the Libertarian Party of Colorado had filed a notice that they were going to be doing a vacancy committee, which they did not have the right to do under Colorado law. But I'm not accusing, whatever. They did not have the right to do that under Colorado law. They disagree. There's been no legal determination of that for the reason I'm going to tell you next, to supplant the rightfully nominated Libertarian Party candidates were RFK Jr. and Nicole Shanahan. And they had noticed an upcoming meeting. I filed a motion for injunctive relief to stop that meeting. Between the time I filed suit and the time of that upcoming meeting, the Secretary of State had issued a letter, we're not getting into the minutia, claiming that Chase Oliver and Mike Tremont were going to be on the ballot and gave the reason why it was. So when I had an evidentiary hearing before the judge to try to get this injunction, the judge basically said there's nothing to enjoin. The Secretary of State already agrees with you. If the Libertarian Party of Colorado wants to bring the Secretary of State into the suit, they can. And then there will be an actual controversy. So it was determined that while there might have been some kind of controversy when I filed the suit, there wasn't a controversy before then because the Secretary of State was already going to do, they already were going to put the Libertarian Party candidates on the ballot. So while this gets framed by some people on the other side, and I don't even like viewing it that way, that I lost that. Actually, I didn't. It didn't win in the court. The Secretary of State independently made their own decision. no one really won or lost. It was kind of determined there's nothing for a court to do at this point. So if you want to view that, I didn't win, certainly, but I also didn't lose. It's kind of like when you look at Robert's Rules of Order, where on a committee, it says if you weren't on the losing side, you can move to reconsider. Now, you didn't have to be on the winning side. You just couldn't be on the losing side. And I kind of view that in the gray area like that. But it was quite nerve-wracking to have to prepare for an evidentiary hearing. I had to prep witnesses. I had to cross-examine witnesses. I had to prepare exhibits. I had to be able to act as if I were an attorney in that. And it was quite disconcerting. And you're at a disadvantage, at least in Colorado, and you might not be at this kind of disadvantage in other things, is I had heard about a case that had presently been going on with the Republican Party that had some similar issues. And I say some similar because the Republican Party here is under major party law in Colorado, and we have minor party law. So there were some differences. But it was such a fast-moving case that I wasn't completely up to date to it. So I got embarrassed at the first hearing because I said this with this Republican case. Well, over like the past 48 hours before that hearing, the decision got reversed. So I ended up saying something incorrect, and I got chastised by the judge for that. Now, the reason why a pro se person is at a disadvantage is because as a pro se person in Colorado, you do not have access to the electronic dockets. A docket is a listing of everything that's happened in the case. Because if I could pay to get access to the docket, where if you're an attorney's office, if you're not one of the representatives for the party to the case, you could still view the docket. You have to pay $15 to have 2 weeks worth of access. You can't do that as a pro se person. You can write the records custodian of whatever court it is and electronically request the records, but that can take sometimes up to a week. You can't keep on top of things as they happen. So you are at a distinct disadvantage. That's not the case, say, in Florida or in DC or in, well, Delaware, you can't see the documents, but I think this is somewhat unusual to Colorado, and I think that is very distinctly unfair. You should be able to pay $15 and see the docket, just like an attorney can. But you can't. But on the other hand, in one of the orders, I don't remember which one, the judge actually said, this is a very well-pled pleading for a pro se litigant. So that was a point of pride, but it was a low point getting scolded for not being completely up to date on that Republican Party case. That wasn't a purposeful misrepresentation to the court, but it was not an accurate misrepresentation. I mean, an accurate representation, because I just couldn't be absolutely up to date. So those are some other pitfalls that you may face in your case. So you do have to know when to dismiss it. I ended up dismissing that case. The other side moved for attorney's fees. They did not win them. And one reason why they didn't win them is A, there wasn't any statutory authority for it, but B, there's always authority if a court determines a case is frivolous. And in my case, the court had determined that they felt I was acting in good faith the entire time. Once it was obvious that the Secretary of State wasn't going to be brought into the case, and the deadline to change the ballot or whatever it was, I don't even remember all the details, so this point is passed, I immediately dismissed the case. So there's things like that too. And I also dropped a records request that I had because I determined I could get the information I needed or I wanted a different way, and I didn't have to get it from the parties. So there was that one case. So it lasted very quickly, but it was very stressful. It's stressful being in front of a judge, but that was a choice. I chose to file that suit. So the next one was one where it definitely wasn't my choice, and it was leading up to the October convention. Not going to get into the details, but I was one of, I think, 30 defendants. You have no choice with that. You have to file a response to defend yourself. And if you can't afford an attorney, and this was a very tight turnaround, I think between the day I got served and the day there was a hearing was 3 days. You're not going to get an attorney and get an attorney up to speed in that amount of time. I suppose if you had a lot of money, you could. But again, even with just an average amount of money, you wouldn't be able to. So, there were several people who got served on that one out of the 30. I think only 2 or 3 people got served. And, responses were filed, or one response, a joint response was filed, if I remember correctly. And that case was also very quickly over with. So to get down to it, this is what I would suggest to you. Again, not any kind of legal advice. You certainly can use AI to gather your thoughts or give you some ideas or give you some wording, but do not rely upon it, not even for when it says pursuant to. I'm just going to pretend like you're in Connecticut. I don't know why. I'm just going to pretend like you're in Connecticut. Connecticut rules of civil procedure, blah, 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 and it goes on. Look up that rule. Look it up. Now, I do, though, have something to say with AI because I do work as a paralegal. I'm familiar with the AI tools that are available to attorneys. However, those are for use if you work in a legal field. That's for use with the job. You can't use that personally unless you have some kind of permission from your boss, and I doubt any boss is going to, well, maybe some smaller firms or some bosses might, but I have seen what there is available on the more professional side. Your average person does not have access to that. And let me give you an example. If you ask, say, Grok, even Grok you're paying for because you have, fancy, one of the upper level blue check marks, you ask it a question, it might take 2 or 3 minutes to answer it. You go into these like Westlaw or LexisNexis companion AI systems, they'll sometimes search and tell you they're going to get an answer to you in 25 minutes. There's a big difference, and there's a big difference to the AI tools and resources that an attorney will have available to them rather than a pro se. So I guess the bottom line is here, if you really have a just cause, again, it just breaks my heart that I think most people are intimidated out of or priced out of the justice system. I would encourage you, if you get an attorney, always, that's your first option. If you can't, then if you've weighed the cost, all of the costs that I have said, then don't be afraid and look up the resources that are available to you. Most courts have a self-help center. They cannot give you legal advice, but they will give you forms. So if you know that you need to file some kind of affidavit and you don't know how to do that, you could call the self-help center and they'll give you a form. Things like that, though, AI is good for. How do I do something really simple? But again, look it up yourself. Because if you look up anything in Colorado, it'll tell you do blah, 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 and then e-file it. Even though you told it you're pro se. There's no e-filing in Colorado for pro se defendants. There is in other states or territories or districts like the District of Columbia, but you can't e-file in Colorado if you're pro se. There is an exception for certain family law circumstances, but generally speaking, you cannot. You got to drive your happy butt down to the courthouse or get a courier to run it to the courthouse or put it in the mail and wait forever. So, those are distinct disadvantages there. So I'm not so sure how much more I can say with it, but I have great sympathies for anyone who does that because, again, I am familiar with the system and it's still really, really stressful. But I remember telling someone, it was someone in the party, but someone entirely different state, entirely different circumstance, where they had found themselves the defendant, and couldn't, for whatever reason, have an attorney on it. And they were a bright person. I said, okay, don't be afraid to defend yourself pro se. I don't know if this is correct. Like, if you could look it up and it would be objectively correct, but subjectively, it's my subjective experience, and it's also partly intuition, that the courts are much kinder and more lenient to a pro se defendant because they were brought into a case. It wasn't voluntary, than they are to pro se plaintiffs. That might not be the case. And I've never seen a case with pro se on both sides. That would be very interesting how the court handles that. That at least would be at least more even, you know. The playing field would be leveled. But also, I'm going to tell you, don't think the other side, because they have an attorney, is automatically right. Read their filings, read their case law, and just use your noodle and be prepared to confidently oppose it if you think it's wrong. A legal case, even though you're going to be drawing in case law and things like that, is basically just an extended written debate. And that could be one reason why I was drawn into the legal profession to begin with. Again, not an attorney. And why I'm not terribly intimidated, even though it is stressful, by being in cases pro se, is I've got extensive written debate experience, years and years of that, verbal debate as well, but a lot of written debate. And that basically is what a lawsuit is, except you have to marshal some authority, statutory, case law, whatever it might be, to your side, and you have to understand how to read it. But how's that any, well, I mean, it is different, but in principle, any different, because I used to do theological debate, than having to look at, like, church history sources or certain, scholars of theology, and marshaling that to bolster your case. It's kind of very similar to, arguing for a dissertation. So I hope that was helpful or educational, or even just kind of like story time, that you heard a little bit of my experience. Again, this was a patron request show. The last time this patron requested a show, how different this one was, on pro se experiences. The last one he requested was, does libertarianism permit voluntary slavery? That was a deep one, and on a total, go look that video up. Maybe I'll stick it up here. I'm kind of proud of that show. I put a lot of work into it. So putting this back up again, really appreciate it. Again, if you would follow me on Twitter. I'm going to move all this out of the way at Karen Ann Harlos. And also, if you become a $25 a month patron, you could even just do it for 1 month to request a show. You can support me on Patreon at patreon.com/Pink Flame of Liberty. Again, there is also exclusive content there. I would really appreciate it. Let's put everything back in place so that when I come back on live, this will all be done. So what is coming up in the queue? Again, I am still researching the George R.R. Martin copyright case that I wish to cover. And I see, in checking the Superior Court docket, that the Macrones have filed their response to Candace Owens's motion to dismiss. You cannot publicly get the court cases in Delaware, but you can write to the Delaware Superior Court clerk and pay for a copy, which is what I'm going to do, but that can take a while to come in. So I'll be doing a show on that. And today I clipped out a clip of the New Evangelicals, or it might have been the Tim and April show, but they're part of the New Evangelicals, critiquing Doug Wilson. who is Pete Hegseth's, it's not his personal pastor, but it's like the head pastor of the, I don't even know if they would call it a denomination, but the movement, the Christ Church movement that he belongs to. So those are some things that are coming up. I appreciate everyone for joining me, and I hope you have an awesome night. Going over here for my closing screen. Bye-bye.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians, or choose to be an accountant because it's safe in the business, not because they want to